Two defendants. Two very different paths. One gets a second chance on probation, the other faces 8 years in prison. Same courtroom. Same judge. Completely different outcomes. Let's break it down.
Good morning. Are you David D'Artez?
Yes, ma'am.
And will your client waive the formal reading of the motion?
He does, Judge.
Mr. D'Artez, in cause number 22-39677, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation July 11th of 2022 for the offense of theft of property, a third-degree felony, and that was a 6-year deferred probation. Is that correct?
Yes, ma'am.
The motion alleges that you violated your probation. Count 1 alleges that you failed to report to the State of Louisiana Community Supervision and Correctional Department March, April, May, June, July, and August of 2024. And is that true or not true?
Yes, ma'am, it is true.
Okay. Count 2 alleges that you failed to report by mail or online to Jefferson County, Texas, October, November, and December of 2022, January through June of 2023, September of 2023, and then November and December of 2023, and then...
At this point, he's admitting everything. When you plead true to probation violations, you're basically telling the judge, I broke the rules, and I accept responsibility. That gives the judge full power to send you to prison, or show mercy.
January through September of 2024. Is that true or not true?
Yes, ma'am, that's true.
Count 3 alleges that you provided a urine sample October 10th of 2024 that tested positive for marijuana. Is that true or not true?
Yes, ma'am, that's true.
Count 4 alleges that you failed to provide verification of performing the community service hours as required. Is that true or not true?
Yes, ma'am, that's true.
Count 5 alleges that you failed to provide verification of completing the theft prevention class. Is that true or not true?
Yes, ma'am, that's true.
And then count 6 alleges that as of October 10th, 2024, you were $650 behind in your fees. Is that true or not true?
Yes, ma'am, that's true.
Did you enter your pleas of true to counts 1 through 6 freely and voluntarily?
Yes, ma'am.
And because those counts are true.
Yes, ma'am.
All right, I have here on the tablet some documents that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am, I did.
Do you fully understand them?
Yes, ma'am.
And you understand if I follow this agreement that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement is for me to continue you on probation, likely extend, and order that you enter and successfully complete ISF. Which program? And probation's here. Thank you for being here, sir. Is this also what you believe would be appropriate for Mr. D'Artez?
Yes, Judge.
Okay. And so is that your understanding of the agreement?
Yes, ma'am.
State tenders number 1.
No objection, Judge.
It's admitted. Any evidence that Mr. D'Artez is not competent?
No, Judge.
Any reason not to go forward today?
This is the turning point. The judge is offering something rare, another chance after multiple failures. Would you take this seriously, or would you waste it? Be honest in the comments.
All right, Mr. D'Artez, it looks like everybody is willing to work with you and give you a chance to be successful on this probation.
Yes, ma'am.
The number 1 thing is you got to show up.
Yes,
You've got to do your reporting online and in person. It looks like you tested positive for marijuana 1 time, which is obviously we don't want you doing, but we don't know what you're doing if you're not showing up. So in my opinion, you probably were doing that a whole lot more and just not showing up. If you continue to violate and not show up in person, not show up online, test positive again, and you're back in court on a motion to revoke, it's not going to go this smoothly. Do you understand?
Yes, ma'am.
So I'm going to find that you entered your pleas of true to counts 1 through 6 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. I'm going to continue you on probation. I'm going to extend your probation by 2 years. You didn't show up for a while, so you're going to get more probation. In order that you enter and successfully complete the ISF cognitive track. And then it sounds like some type of aftercare, substance abuse, depending on where he is, would be appropriate. So if he's back here for some reason, JCDI. If not, and he ends up back in Louisiana, some program like that for any type of drug issues. So I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. All right, take advantage of this. All right, good luck to you. You can go back with the bailiff. And you. Good morning, sir. You're Corey Flemings.
Yes, ma'am.
And Mr. Flemings has two cases, 24 DCCR 2144 and 2145, set for trial to begin with jury selection next Monday. What is the announcement?
Judge, we're ready, subject to a ruling on my motion to quash the enhancement portion of the indictment.
State's ready to proceed.
I would ask which case Mr. Coleman intends to try first.
We intend to try the assault on the peace officer, Judge, and put on punishment evidence pursuant to our notice of extraneous offense of the injury to the disabled person.
And so the enhancement portion wouldn't change anything other than potential punishment.
Yes, ma'am. It would require you to declare a penal code statute unconstitutional.
Oh. That would be novel for me.
Yes, I figured it was. I have a case pending in the 9th right now with the same issue.
So hold on a second, let me look at the indictment. Is the enhancement alleged? Yeah, so it's alleged in the indictment, and so I would need to make that ruling prior to jury selection.
Yes,
So
ma'am.
that, well, we don't talk about punishment range in the jury selection. We'll talk about it. I'll get the case numbered. And then if it's numbered 1, we'll handle it either prior to or just after jury selection, because it won't change anything that you say in
I
voir
think
dire.
that if the punishment range is 25 to 99 and he is convicted and goes to the jury for punishment, I do believe I get to voir dire on the potential range of punishment.
And if he gets to voir dire on it, certainly the state would ask for reciprocity on that.
I don't have a problem with that.
Well, here's how I handled any enhancements on punishment and how I would intend to handle it is I do not go into specifics or allow you guys to go into specifics. I will, in my part of talking to the jury, explain that there are different circumstances that could lead to higher punishments or lower punishments depending on the evidence that's presented. But getting into specific, especially priors, if I'm going to make some ruling potentially that they're not admissible or that we're not going to get to until punishment, we're not going to get into that on guilt innocence. We're not going to get into it on voir dire very specifically, other than if there's something, because if you allude to it too much, I think you're putting yourself and your defendant in a position where you're telling a jury up front that he has potential criminal history that could go into their decision-making in guilt innocence. So
Yes, ma'am.
we're not going into that. I'll say what I say, but as far as spending a lot of time on it, that's not going to be an issue during voir dire. I'm not going to allow it to be one, but I will make the ruling that day so that we know before we get started. If it's going to change anything about the status of trial, and if I deny it, y'all want to renegotiate, or if I grant it, then let me know that. If you think it'll change anything, then I can make that, we can get something done either later today or tomorrow. I'll take a look at it so that you know ahead of time, because I want to know that.
Now we shift to case number 2, and the pressure is on. The judge just denied the motion to weaken the charges. Translation: trial just got riskier, and prison time just got closer.
You know, if I deny the motion to quash, which it sounds like I likely am not going to find our penal code section unconstitutional, if that changes Mr. Fleming's position, y'all talk about that today, because I want to know that if there's going to be some type of negotiation and a plea, I want that done today.
Yes, ma'am.
Okay?
Court's information, regardless of how the court rules, the state's prepared and willing to proceed with trial.
Yeah, no, it's gonna be numbered, and we're running low on, I mean, the number one just pled this morning, and so it's likely this could go. So I want serious, talk to Mr. Fleming's. I've looked at the motion to quash. If y'all want to talk about it real quick, I can let you make your argument at this point.
I think we already talked about it.
I think we did, and so, I mean, I can go ahead at this point and deny that motion to quash that you filed, and so that way, we've talked about it. I've read the state's brief. I've read what you filed, which had your information in it, and so that being done, y'all, if y'all want to talk, if that changes anything.
Yes, ma'am.
Okay, so do you want me to hold it while y'all visit?
I've got a meeting I've got to go to. I will visit with him, and then if it's gonna be a plea, I will advise the court. and
No, it's
we can-
gonna plea today.
Yes,
Y'all
ma'am.
need to talk now,
Yes,
or
ma'am.
before docket's over.
Yes, ma'am.
Okay, I'll hold it.
All right. And then the discovery.
Thank you. I need the NDA to sign that, please. Okay. All right, again, you are Corey Flemings, right? And will your client waive the formal reading of the indictment?
Yes, ma'am.
And we are going forward just in 2144, right?
Yes,
Yes,
ma'am.
Judge, and the state's waiving the punishment enhancements.
Thank you. Let me get that pulled up properly. And he'll waive the formal reading.
Yes, ma'am.
Mr. Flemings, in cause number 24, DCCR 2144, the state has elected to proceed on count one only. It alleges you committed the second-degree felony offense of assault on a peace officer from September 11th of 2024, and how do you plead to that charge? Are you,
If I may, I think I marked that it was the third on the plea papers. If we could change that to the second.
we'll get that done, thanks. All right, so I'm making that modification to second degree with everyone's permission.
Yes, ma'am.
Yes, Judge.
And so how do you plead again to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Radford? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objections.
It's admitted. Is there any evidence that Mr. Flemings is not competent?
No, ma'am.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of assault on a peace officer. Sentence you in accordance with that agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I will sign a dismissal as part of that agreement in cause number 24, DCCR.
And here's the final scorecard. D'Artes gets extended probation and treatment. Flemings takes an 8-year prison deal. .1 walked out with hope. .1 walked out in cuffs. Same courtroom. Different choices. Which outcome do you think was fair?
2145. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Radford. All right, good luck to you, sir. You can go back with the bailiff.
Thank you, Judge. May I
Thank
be
you.
excused?
Yes, thank you, sir.